think in short, I'm a lawyer. So probably you will hear something cynical about what I'm going to present. Having worked in the power sector on and off, I won't claim that I've been in power sector as many years as probably Mr. Rahul is. Having looked at various aspects, it gives me butterflies when I have to speak in Nagpur, because the Nagpur tradition is that even Lata Mangeshkar had to kind of face a barrage of chappals while she was singing. So pardon me if I kind of go overboard. Don't do that to me. What I propose to do is to look at what the issues are today, what the problem issues are today, and probably then look at what probable solution on one or two aspects. I'm just trying to kind of understand what the myths were when Vidarbha was considered as a region for creating thermal power stations, and what are the kind of broad issues there. We said 32% of Maharashtra area is in Vidarbha, 20% of population resides here, and 29% of total installed capacity is in Vidarbha. There are about 41,000 megawatts in pipeline. This was about a couple of years ago. It must have increased over the period of time. One of the very critical aspects was they said Nagpur is in the center. And I draw an analogy to Muhammad Tughlaq. Tughlaq moved his capital from Delhi to Daulatabad. He just drew on the map what is the center of the country. Experts in kind of administration kind of hailed this decision to say that it was probably a perfect decision at that point in time. The vast tract of land available, he had conquered southern India or parts of southern India at that point in time. He knew he had to kind of control that from the administrative perspective. He thought it was a brilliant idea. He moved to Daulatabad, and all of us know what happened thereafter. See, Nagpur is a zero-mile city. It's in the center of the country. It's in the center of the grid. It's in the center of highway grids. It's in the center of power grid. It has vast coal deposits. 100% of coal that is available in state is in Vidarbha. So everybody thought that this is a coal belt. And look at what's happening. If you look at the statistics today, and this is again, I think 2012 or middle of 2013 statistics, only 42 megawatt coal out of 13,554 megawatt that is getting produced is based on uses local coal here. So the first myth and the basic premise that this is the coal belt and therefore it makes sense in kind of putting up 420. I'm sorry. Therefore, you should have thermal power plants in Vidarbha. The first myth is what the statistics are taking. The second myth is that there are large tract of lands available here which were not as fertile probably as in Konkan belt or Western Maharashtra and some parts of Maratha. So everybody thought yes, the land which was largely land would be available. But if you look at what's happening to the land, because of the lower GCV of the coal that is getting used here, there is a large fly ash that's coming out of the power. And that fly ash needs large tract of land to the extent of 1 acre per megawatt would be required for fly ash. So a large tract of land would be required. Water reservoirs, underground, overground, was considered to be thermal power plants. We need water, and what is the situation as to water today? We're talking about sewage water being used, municipal sewage water being used for the purposes of power plants. And I ask myself, are we serious about it? Therefore, Vidarbha, with 100% of coal deposits of Maharashtra, with so much of capacity which is here currently, has tremendous challenges in terms of whatever has been the historical perspective. There are very fiery factors, and I would like to kind of take you through some of them. If you look at the economics, the per capita income is probably lowest in this region. You compare Amravati division to Thana division, you look at 46,000 compared to 109,000 in Thana. You look at Nagpur district, it's somewhere 81,000, Washing 36,000 per capita income, and Mumbai 125,000. What's being said is that the four core sectors in Vidarbha offer $20 billion investment opportunity. You look at that in comparison to the NPAs that are there today, with the stranded assets that I talked about. I think what are the stranded assets here today? Look at what's happened. I mean, traditionally, if you look at cotton growing region, there were sugar mills like in any other kind of part of Maharashtra. And sugar mills have gone down. Cotton and textile, all of us know what is the vagary with respect to the monsoons here. And therefore, today, in terms of the ancillary industries that are there beyond the four core sector, are completely kind of either downgraded or are missing today. They are marginalized. Whatever might be the reasons, political, economic, financial, NABARD has put its foot down post the Maharashtra cooperative collapse. They have said, sorry, we're not going to kind of expose ourselves anymore. So the agricultural rural credit is not available in the region today, except for some of the schemes that may have come due to farmers suicide and various other aspects. I mean, when I started working in the energy sector, one of the prime thing was, fine, there is a power deficit, so you probably have consumers there, industrial, residential, commercial consumers. It was B2B or B2C, but there's enough demand available. And I think the story is still there that there is enough demand available. If there is a ready and willing buyer and ready and willing supplier, there would be a contract to the effect, and that's all as a lawyer I believe. But one of the most critical aspects was, and that I remember when we started earlier in power sector was quite clear, if you don't have fuel supply agreement on a long-term basis tied up, you're not setting up your power plant. I think over the period, FSAs have gone. I mean, today, nobody talks about FSAs. If they are kind of short-term contracts. Then we talked about, work on letter of allotment. We'll allot you coal based on the letter of allotments that you will have, and based on that, you go towards financial closure. As a developer, you're getting a comfort that, yes, if there is no FSA, there is letter of allotment. That gave way to just saying that we will provide you linkages. And then the fuel vanished. So the prime raw material, which is fuel, is a vanishing fuel today. I mean, you look at, which is getting complicated by the coal block allocation order of Supreme Court. If you read all that order, you will realize that, there are far too many things to be talked about in terms of policies and in terms of implementation of policies and how the courts view it. Coal handling is difficult. Now, as I mentioned to you earlier, it's only 420 megawatt that's supported by local coal. The balance is all coming from coal which is distant, which could be Orissa, which could be imported coal. So coal handling becomes very difficult. You look at the GCV value of coal here. As it is, Indian coal has a bad name in Burma. I mean, they say the GCV value of Indian coal is really, really poor. Despite of that, what we have here is in this region specifically, the GCV value of coal is far below the weighted average of coal that is required or currently used by coals. So that's insofar as fuel is concerned. First is finance, second is fuel, third is fly ash. Now fly ash, if you look at the timeline there, 2004 something happened, 2006 something happened, 2009, November 2009 MOAF notification which says 50% utilization of fly ash has to be there by the thermal power plant. Has this really been achieved? Yes, there are statistics, there are numbers which say by and large they are there in terms of 50% achieving the utilization of fly ash there. Again, nobody has really audited those figures. Terry has gone there as a together with CEA and produced these numbers. But if you look at what's happening at the ground level, actually, I think everybody is crying, whether it's public interest groups or whether it is individuals, whether it is residential colonies next to the thermal power plants. Everybody in Vidarbha is crying, saying that please don't reduce Vidarbha into ash town. And I think we can give various statistics in terms of what all has been the land that we require, what is the fly ash kind of removal, what is the fly ash utilization. The fact remains that there is a rise in temperature between 3 to 5 degrees because of fly ash just remaining high. Again, a kind of complex situation arises post Jan 2014 notification of MOAF which says that ash content of the coal that you are going to use shall not exceed 34%. That's another problem there. Sorry, shall not exceed. My apologies. Then when we look at finance to fuel to fly ash to farmers, I mean, what's happening? And I asked myself, is there any correlation between farmer suicides and actually the thermal power plants or the power sector here? And one has to come to conclusion based on whatever experiences that we've had. Yes, there is a degradation of environment all across, whether it is underground, overground, river beds. Every monsoon, we've seen fly ash just being dumped, or there are accidents that happen, and therefore fly ash finds its way into rivers and river beds. What's the consequences? It has a long-term underground pollution effect, which reduces the fertility of the soil, which reduces the overall kind of environmental quotient that is there. So that's another problem there. Again, are we really kind of listening to the farmers? Are we really kind of taking their point of view, whether by granting the environment clearances or otherwise at the regulatory level? And I would like to quote Grace here. Grace is a poet, a very great Marathi poet from Vidarbha region. And he kind of says that, "He sarta sampat nahi and bhay itle sampat nahi." This is the land where I think that fear doesn't end. Problems are compounded. I don't want to get into the micro level in terms of the regulatory interventions that happen. I think very clearly, when we look at the statistics in the World Bank report on the regulatory environment in India, we realize in the first place there are no benchmarks. There are no benchmarks in terms of development of accountability in the region. There is no uniform approach, although there is a statement in the legislation that yes, there has to be uniform and harmonious rulings across the jurisdiction. That's not happening. What is getting created because of the difference between the cost and the tariff is really there are regulatory assets. I mean, beyond stranded assets, we'll have to also think in terms of what is regulatory assets. Very clearly, I think the regulators are saying we can't afford extra tariff today. So you got to get, or you will be given tariff which is X, and your cost may be 2 times X, 1.5 times X, at times it's 1.2 times X. But that 0.2% is the delta that's sitting out there, where everybody is saying that we will use that delta to compensate you subsequently. We've all kind of going through this proof of mechanism kind of a situation and what's happening there. But the fact still remains that we are moving towards creating regulatory assets. So even if we move from standard assets, if we end up creating a large regulatory assets, we would still have problems. On the 3 parameters, I think globally benchmarked Indian regulators have still lot of things to do in terms of autonomy, capacity and transparency. One of the key elements as we move from regulatory towards corporate governance is, and this is one thing which I'm very passionate about. When we talk about corporate governance, the first thing that comes up is compliances, and first thing that comes to your mind is the stakeholders around it. Notwithstanding the New Companies Act, which defines and broadens the stakeholders, I think very clearly what we have to see is if there is a violation of law, what are the consequences? Now, if you look at typically at the Water Act, what happens is you have fine of 5,000 per violation. You have additional 1,000 for every additional violation. Are we scared of imprisonment? Are the promoters scared of imprisonment insofar as there could be a non-compliance? And I think no. They're saying, yeah, prosecute me after due process of law, and we all mean what is that due process of law? Are they worried about reputational damage? I don't think so. Nobody is worried about reputational damage. The media will kind of throw some of the things out in the open and in public. It's a short-term memory. People are going to forget about it, and the business will go as usual. They're not worried about reputational damage. All across the world, cost of compliance is lower than cost of non-compliance. Fine, mainly because the fines and the penalties and the damages that the corporate entity kind of suffers because of non-compliance is much higher. Here, the cost of compliance is far greater than the cost of non-compliance. Again, linking corporate governance with the performance of the utility, I think that's one area where I don't think either government or the regulator or anybody has done any kind of study. And therefore, corporate governance and performance of utility is one linkage that might result into some kind of a push that you have. We all know that there's a competition amongst various regulators. Who will levies higher fines? Who can penalize somebody more? And it's getting complicated with MOAF modification of January 2, 2014, which says that the ash content not exceeding 34% on the quarterly average basis of thermal power plants. National Green Tribunal, the Western Zone kind of issue had proceeding before it. They called up Mahagenco, they made everybody a respondent there, and said that fine, reply to what the complainant or applicant had to say. Nothing was taken seriously. Eventually, the NGT on October 31st issued bailable warrants and said that this is first step. Next step is going to be non-bailable warrants if you don't take us seriously. What was the problem? The problem was again the ash and the ash content and whether the notification, which was the law, legislation law of the land, whether it is being kind of implemented or not. Through the RTI, I think the statistics is up there. Whether it is Kaparkeda plant or whether it is Bhusawal, I think the ash content is much higher than 34%. So the National Green Tribunal, in times to come, is going to be more active. So there's going to be this push and pull in terms of the environment, in terms of the promoters or the developers' objectives, in terms of consumer objectives. In all this kind of a rigmarole, again, I would go back to Grace to say that स्तोत्रात इंद्रिये अवघे गुणगुणती दुःखाचे गाणे हे सरता संपत नाही भय इथले संपत नाही. That's the state of Vidarbha. Do we have solution in sight? Very quickly, I think last budget, they said, yeah, the critical part about this is, you have to look at long-term financing, and what Harry said is in terms of whether you have PPA, which is or a plant which has a 25 years to 30 years kind of a life there in terms of it being typically a power IPP. The 525 structure has emerged and 525 norms have emerged. What do 525 norms say? They really say that after every 5 years, the banks or the lenders might come together and look at how do we re-amortize the entire debt chain. I mean, that's where I think they thought probably that's something which on the asset side would look at a kind of a rollover there. They said, for this, on the liability side, we must help the banks. So they said that minimum regulatory preemption on CRR and SLR would be available insofar as the priority sector lending is concerned. That was the kind of intent in the budget statement. Recently, December 8, 2014, all of us know Piyush Goyal kind of said that we want to ensure 24/7 power and make India capital of clean energy. There's 400 billion investment opportunity here. You look at, again in December 2014, what RBI did was, initially in July of 2014, I think RBI gave that 525 push and said that for all new projects that would come up after July of 2014, you can look at amortizing your debt or amortizing your capital structure so that every 5 years you can consider, overall maybe 25 years, but every 5 years you look at it. So the long-term debt is being taken care by rollover every 5 years, broadly speaking. December 2014, I think the governor said that two things which happened very interestingly. The 525 norm was extended to standard assets which are existing, not the stranded assets, I think. One of the criteria was the account should not be NPA. But 525 could happen there. Sorry. He also said, and which is really reading the line there, is that the banks will take position on the equity restructure together with the debt restructure. What would happen is, if you have kind of taken debt for a period, for a long-term period, the working capital requirement, capital debt restructuring would happen in such a manner that in the capital debt restructuring, you could probably look at equity participation to a greater extent by the banks in order to make sure that you are restructuring the debt correct. Again, nothing has come out as yet because as the kind of governor said there, in discussion with SEBI on the issues of what would be the conversion price, etc. But it's likely to come. Insofar as NPAs are concerned, he said, yeah, you won't qualify as a standard asset if you are NPA, but if you come out of NPA, we will consider you back for restructuring on 525 notes. That's kind of a debt re-amortization process that will happen. So the moot question is, these are the three people that are kind of, who can probably look at providing solutions at a broad level. And when you have NPA, and that's most of the cases in terms of the standard asset, nobody is answering this question as to how do you move that NPA to a performing standard asset so that there could be debt recast, and how do we move it forward? I'll move on to a couple of legal overtones in terms of powering Vidarbha. Again, standard assets, the judgment on 28th of January 2015 from the Supreme Court bench, which had Justice Mr. S. again, what it said very clearly is that Surfacing Act's objective is to make sure that you are moving very quickly. And we all know how much time do the banks take to move in quickly, and what's the kind of structure that they follow. If there is NPA, if the asset is moving towards getting completely non-performing asset, how do you quickly move in and take over the assets? That objective was really speaking that liability should be discharged within 60 days, and therefore give a notice, use your step-in rights, step in and take over. The problem here when this matter came up to the Supreme Court was primarily that you had various time limits for taking action and declaring an asset as an NPA under various different standards. So in as much as, let's say, Exim Bank, if you were to look at it, Exim Bank said 180 days is fine. RBI said 90 days. NHB said, if it's a housing loan, look at 120, 180, they keep shifting. So obviously, when the matter came up, I think it was through various writ petitions that were filed across the High Court, which challenged the constitutional validity of this provision under SARFAESI Act, which gives 60 days for declaring an asset as NPA. Post whatever RBI guidelines and norms are default. Supreme Court said nothing doing. It's perfectly and constitutionally valid. Gujarat High Court have held that it is unconstitutional and invalid. So in the process, from I guess 2004 to 2015, nobody knew, truly speaking on NPA, what is that period we should come. I think Supreme Court has set that aside today. They said that 2002 amendment is constitutionally valid. So courts are slowly moving towards saying that if RBI prescribes prudential norms which are different from NHB, which are different from Exim Bank, don't worry about it. The respective regulators and legislators will have their say with respect to their lending and borrowing in their domain. So obviously, I think this is where stranded assets, which are today considered as NPA, might want to consider as to what is the role of the lenders here under the SARFAESI Act, and the courts are going to view it primarily from the lenders' perspective. When I look at statutory rights, of course the RBI guidelines, prudential norms, NPA guidelines, all of them give right to the lenders to step. Over and above that, there are contractual rights. The contractual rights are available to lenders, and this is some of the projects that are stuck here. Shirpur happens to be 1,800 crores. Vidarbha. As I said, the RBI guidelines, there is legislative intent, there is statutory provision, and over and above that, there are contractual rights. Question to all lenders would be: you've taken at the time of financial closure, you really move to take all contractual rights, including the step-in rights. What does that mean is that if your account is NPA, if you are unable to kind of service the debt or any capital for that matter, debt or interest, then probably we will have step-in rights. These are PPAs. These are kind of where build, operate, fundamentally exist. When this happens, at the financial closure, you're taking consent about the lending documents from everyone. So, implicitly and by derivative, these are binding on everyone who is a stakeholder in that particular project. So, obviously, what prevents banks from moving very quickly and taking over the assets? One of the very, very fundamental issues there is that today the banks, through NPAs and asset reconstruction companies, have got into this kind of a tiff, where they're saying that we will take over the assets which are NPAs, but we don't know what to do with it. Many times the banks have said that we're just going to give it to the ARC. ARC doesn't have the competency to run the power plant. ARC doesn't know what to do whether if a PPA is stuck, what is it supposed to do. So obviously there is a pool of experts that will be required at ARC level. And I can here step back and look at what happened to Enron, and I've worked there, and therefore I can kind of correlate that very well. And it's something where even if the controversy emerges, Enron has been submerged in other deals, we can all talk about. Initially, when there was a problem in terms of operational characteristics of the plant, government didn't have money to pay the capacity charges primarily. There were commercial issues, dollar-denominated tariff. Government saw it fit to shut down the plant. 752 megawatts and 2,500 megawatts phase 1. All shut down one fine day. We were working in Enron. We realized that the machine, which was at that point in time frame 6 machine, very delicate machine. We say that if it doesn't function and lies idle, it's going to go sour. It's not going to give you the capacity or the efficiency, or it's not going to kind of perform. So we were kind of running helter and skelter to see that how does one convince somebody to say that let the plant run. Because even if a plant shuts down for 3 months, 6 months, as a prudent businessman, you're scared. You put in your investment and you're really scared. So we tried to form a cooperative of the employees and gave comfort to lenders to say that why don't you step in very quickly. So they stepped in. And they invoked the provision which was like the preservation and protection of asset provision under the lending companies. They said we're taking over the plant, this is not performing, we will preserve and protect the asset in the interim stage while our step in etc. will be determined subsequently. So they took over the plant. Who did they have? They engaged contractor who was expert in pipelines to protect the asset which was like the GE frame 6 mesh. A completely automated plant. What happened next? A global level settlement was arrived at through an international kind of bilateral investment treaty arbitration. Government of India agreed to pay $450 million to the shareholders of Enron. Then Enron wasn't there, GE paid all that money. At that point in time, they constituted Ratnagiri Gas and Power. They said, what do we do with this asset? So they constituted Ratnagiri Gas and Power. All this while, we were trying to tell the government that we are employees at Enron. We will come forward and we will run the plant. Because there is a power deficit, please allow us to run it. Because the same kind of operator who was engaged by Enron was working with us. He was part of us. It never happened. Ratnagiri Gas and Power eventually, from 2001 it was shut down. Somewhere in 2008 or 9 it was revived. The daily capacity was achieved in a month, and that's how Ratnagiri Gas and Power functions. The point that I'm trying to make is that if you take, let's look at the corporate governance on one side, let's look at the operating management on the other side, and if you really empower them to find solutions, and lenders move in very quickly to take over these assets so that they start functioning and running very fast, I think there could be light at the end of the tunnel in terms of saying yes, the imponderables in terms of power purchase agreement and the fuel supply contract. I think as professionals, if we're working in that sector, we know how to crack it. It's difficult, at times it's impossible, it gets into political rigmaroles, but we know how to crack it. So again, I would like to mention here, ending note, is that Bhai Itle Sampad Naik, that's all right. But the poet from same region, Amravati's poet, Suresh Bhatt, he said, Ushakal hota hota kala ratra zali. Are puna ayushyacha petava mashali. It's in the hands of the professionals, and if you empower them very correctly and rightly, I think you may probably have solutions which are unheard of. Thank you very much. Thanks a lot.